Okay. Hi, everyone. Welcome here on this panel where we will be discussing some of the legal complexities and the legal nuances around the gaming world. Of course, being one of the sector which has seen exponential growth in the last few years, gaming obviously as a sector has seen its own set of legal complexities. And to understand the legal nuances is very, very important for success and growth of anybody who is part of this ecosystem. We have a great panel today with years and years of experience in gaming laws, and they are the experts of the knowledge, who have all the legal knowledge around the gaming world, and who will help us navigate through the legal nuances and shed some light on the key legal challenges that we have. With that, I would like to first welcome the panel. Thank you so much for taking out the time today. Actually, I think let's start with probably Jay. I think you have had a liking towards this sector for really really long, and you come with years of specific gaming law experience. Last year has been very eventful for gaming as a sector, with a lot of movement on the legal side with new gaming laws, with TDS, with GST, new taxation laws. Would you like to throw some light on the a lot of legal ambiguity and a lot new legal challenges that is coming?
Yeah, thanks, Ritika, and good evening, everyone. So, as you rightly said, last year or last couple of years, rather, there has been a lot of movement on the regulatory front, uh, both from the regulation perspective as well as the taxation perspective. And almost all the changes that we have seen are, distinguished between real money games and non-real money games. For example, I'll take the GST issue first because that's an issue, which the press and everyone has been talking about a lot. So yes, from 1st of October 2023, uh, there have been changes to the GST legislation, but they have been more from the perspective of online money gaming. So there has been a new definition of online money gaming that has been inserted, which wherein a game where a person deposits either in cash or kind something with the expectation of winning something, and this includes, of course, deposit in the form of virtual tokens or crypto, etc. And there is an expectation of winning something out of that deposit. Then there has been a new regime for GST for all these gaming companies, which is that they have been treated to be supply basis 28% on every deposit made in the wallet of those online money gaming platforms. So that has been the change as far as GST is concerned. Now press and everyone else writes online gaming 28% GST, which is slightly confusing because online gaming, which does not involve money transactions, what I said about deposit and withdrawal, that continues to be at 18% under a
Right.
different SAC code. So I hope that clarifies a bit of confusion about the GST aspect. Uh, of course, there are a lot of other nuances about the retrospective GST and the litigation surrounding that, but that may not really be relevant over here. And considering the time, also I won't touch upon it. Second thing was the TDS. Again, that changed from 2023 financial year, wherein net winnings there is a 30% tax regardless of any threshold. So any winnings given to users, of course, there's a complicated formula for net winnings, but that is again more relevant for real money gaming, apps. So any winnings, there is a TDS compliance that has to be done. 30% TDS has to be deducted, regardless of whether a person is making a deposit or not. So that just says online gaming intermediaries and online games. So TDS is agnostic to real versus non-real money gaming. Both have to comply with the requirement. The other bit is around regulation. Of course, there has been demands both from real money as well as non-real money gaming sector that there should be some kind of regulatory framework, either a self-regulatory framework or uh, either the Ministry of Electronics and Information Technology or Information and Broadcasting should come in uh, and go ahead and regulate this. The government, central government specifically allocated part of this subject to the METI, which is the Electronics and Information Technology. They came out with certain rules uh, to regulate the industry, but that is again more from the perspective of online real money gaming. Of course, those rules have a condition that any online game, they if the government feels it is necessary for public order and so on, they may ask them to also fall within the framework of real money gaming, and that framework envisages creation and approval of self-regulatory bodies, but none of that has happened. So that is in a bit of a flux. There'll be a host of compliances for online real money gaming companies once those rules kick in, but the self-regulatory bodies have not been approved, and the rules itself clearly say that they will apply 3 months after three self-regulatory bodies have been approved. So that process is in a bit of flux, and government is considering various demands and requests from the industry and seeing how best to come up with a framework. At the same time, there is also this issue of uh, you know uh, state versus center. Certain states have gone ahead and sort of framed their own regulations, regardless of MIT doing something or Information and Broadcasting Ministry at the center doing something. Uh, Tamil Nadu has its own Tamil Nadu Online Gaming Authority, and they intend to come up with regulations for all sorts of games, including time, age, and monetary limits. That is again a process of consultation, etc., which they are going on. So we'll have to wait and see what framework they bring in and what the other states also do in this regard. So all I will say, it's exciting times, and we have not seen the last word on this, on the regulatory piece, and things will continue to evolve in the next few months.
Yeah, thanks, Jay. I think the what you rightly mentioned is the flux bit, right? So I think I'll come back to you, Murtaza, on this. That flux is obviously one of the if flux in the regulatory sector gives a lot of anxiety to investors. So specifically for gaming companies trying to raise money, how should they go about it? What are the things that they should keep in mind?
Thank you so much, and good afternoon, everyone. So, I mean, just a little background. I'm Murtaza. I'm a partner at a law firm out of Mumbai, and most of the work that I do in the gaming sector is where I advise a lot of my clients in acquiring or investing in gaming studios. So, I think so the question is very apt because when we are assisting our clients in doing those acquisitions, it's very important that we do a health check of how the studios have, not perform business wise because that's not my job, but are they healthy in terms of compliance with regulations? Are they healthy in terms of have they kept their books properly? Have they complied with the tax laws properly? And a few things that we see almost like even without looking at things, we know that there are going to be problems. Are things like, for example, GST. Now GST becomes a problem not only because of online real money, but because like any other business which is bootstrapping, cash flow is a problem. So when you get that 18%, you want to use it to pay out your next salary and not necessarily there to deposit it. So there are
Right.
you have those delays and stuff. So I think that is something that you should plan for in terms of how you manage your cash flows. And because if there are GST delays and those things compound up and become big, that's something that the investors then going to uh, say that if things go wrong, they're going to come after the founder or the entrepreneur to foot the bill if things go wrong. That's something that you should be careful about. I think another big issue that is key is that um, intellectual property, and I'm sure my colleagues are going to speak on it, but purely from a transaction perspective, it's very important that the employees or your other developers that you engage to help you in building the games or developing those games, you enter into good contracts with them on day one, because the unlike trademarks where it is very simple to register a IP, you just go to the trademark authority, register the IP, and life is good. But when it comes to the games and especially the software and the source code, it is not as simple as that. The whether you have the title to the IP or not will all depend on how your contract with your co-developers, your consultants, your employees are there, and that's very important that you make sure that you have necessary IP clauses, because many a times we see that as part of our advice, then we ask them to go and get assignment of IP deeds or assignment of IP kind of letters from all your previous developers or co-developers, and sometimes you don't know where that person is. Sometimes you don't know how we broke up with them, on what terms. So, those are things that it's best to be careful of. And I think the other important thing is also that, again, when you're bootstrapping, a lot of money you are taking from your friends and family. So it's again very important to how you take that money. Do you take that as a loan? Do you take that as shares? If you take it as loans, there are rules around who a company can borrow from, who a company cannot borrow from. A company cannot take a loan from an individual unless he's a director. You can only take a loan from maybe a bank or a company or another company. So it's just important to call your company secretary or your lawyer friend or whoever it is to just check that I'm doing this transaction is good. You're taking money from your friends and family. Someone's invested from sitting in LA or California and said, okay, now I'm going to cut a check to you and send it to you or someone else. But you've not complied with the laws around taking money from a foreigner, from a non-resident, right? And those things then become a big problem later when someone is going to invest, because those shares are not easily transferable. Those shares, you cannot invest in that company unless those compliances have been sorted. So these are a few things that you really need to be careful about.
Right.
I think the other aspect is that if you're raising funds from institutions which are not based in India, which are based out of India, I think a few things to be careful about is if you're doing real money gaming, it's a whole different world there. Gambling largely is not permitted. And if you're real money with skills, you need to make sure you are in skill, that this shouldn't be challenged. Later, I don't want to get into that, but as long as you're a skill game, you're not gambling, you can raise funds, but people tend to be a lot more careful. They want to make sure that you have opinions in place. The features of your game do not go beyond, do not make the game, while it tends to be skilled, but it is, while you're actually playing, there is no skill. So those things you got to be careful of, because it's very subjective. It's not necessarily a clear bright line test. And I think there are other issues about raising funds from, say, probably from China or something else. There are rules around how much you can raise from them, rules around what kind of permissions you need to take. So again, I think the thumb rule for everyone in this room is that if you're raising money from someone outside India, you gotta call your lawyers and check and make sure that all the boxes are checked before
Right.
you do that. So yeah.
Right. Thanks, Murtaza. I think that's a very interesting point on the IP and the contracts, and I'll just come back to that. I need to divert for another hot topic on the gaming piece right now, and then we'll come back to the IP piece. Siddhartha, just wanted to pick your brain on another hot topic in gaming, DPDP, the data protection laws, right? Like, I think it's been on the news for really long, and how does it impact gaming companies? How should they go about it? Of course, there are other angles to age dating, protection of young children, and about it. So, what are your views on that?
Uh, Thanks, Ritika. So just to introduce myself, I'm Siddharth. I work at Poovayya. If I'm honest, I'm a general corporate lawyer, not specifically focused on gaming, but I do have a very clear interest in gaming as a field, and therefore I like doing gaming work. I have an interesting job now in terms of trying to talk about data regulation and make it interesting for you people. So I'll try to do that. The only way I can do that is by being not getting into the nuance too much, because if I get into details, you guys will fall asleep. So I'll try not to do that to you. But if just keep in mind that there is nuance that I'm not dealing with, just in the interest of keeping this interesting. So at a very high level, there are two laws that you need to know about. One is the DPDP Act, that's the Digital Personal Data Protection Act in India, 2023. So it was passed last year. It's not come into force as yet. So it's still not in force. The government has been telling us for the last few months that the rules are going to come out imminently. And they've also said, forget about the rules, you should be complying already. Don't wait for the rules. But the practical aspect is the rules are not out, and it'll take them some time to bring the law into force. So that's on one side, that's on the Indian side. The other important law to know about is GDPR. That's the General Data Protection Regulation from the EU. It applies to EU countries. The thing to be aware of there is that GDPR came into force a long time ago, not a long time ago, a few years ago. And the enforcement mechanisms are up and running, they are working. orders have been coming out from the data protection authorities in the EU. So if you have a business that in any way targets the EU, you need to be aware of the GDPR and compliant with GDPR. So you need to be talking to your lawyers about how you're handling data. If you are targeting the India market, I probably shouldn't say this as a lawyer, but you have a little bit more time to comply because the mechanism is not in place as yet. And also just, again, I shouldn't be saying this, but just keep in mind that even once the mechanisms come into place, the enforcement mechanisms, given the budgets that the government is going to give them, etc., and how they would want to enforce, they're going to look at the large players. They're going to go after the big intermediaries first. They're not going to go after small studios, etc. I'll give you one caveat here. Unless there is a data breach, you have to be so possibly the one very important takeaway you should have on the data side is that your data security has to be in place, and that's not so much from the perspective of yes, it's required from a legal perspective also, but just from a practical perspective, if you have a data breach, you're going to have a lot of scrutiny from enforcement authorities, and you don't want that. So that's the first key takeaway I would say, that make sure that your data security measures are in place. Now, in terms of what the law actually provides, India's DPDP framework is based on consent. It's entirely based on consent. There are some ways in which you can process data otherwise than with an affirmative consent, but the consent is the most important thing. So your sign-up process needs to be carefully thought through. The consent has to be affirmative. It has to be clear. You have to clearly tell your users what you're going to use the data for and how it's going to be processed. So all of that has to be clearly laid out. So you have to think through your sign-up process. And after that, one important thing that you have to keep in mind is that your users have certain rights under Indian law, which you need to be cognizant of, because you will have to build these into your infrastructure to make sure that you can provide this to them. So what users in India can do or ask you to provide to them is all the information that you have about them and how you have processed it. They can also ask you to disclose to them who have you given this information to. So if you are providing this user information to third parties for other processing, for some ad platform you're using, if you're using a third-party mailer platform and you're providing email addresses to them, all of these, a user can come back to you and say, I need you to tell me who all you have given my data to. And you have to be able to answer that question. The other thing is that they can ask for their data to be corrected, to be changed, and to be deleted. So you have to have the infrastructure to be able to do all of this as well.
Right.
So just keep in mind that just from the perspective of being able to comply with this, you need to have these steps in place. You also need to possibly minimize the amount of data that you're collecting so that you don't have so much that you're worried about. But I mean, I understand that there's a trade-off between the business use of the data and how trying to minimize as much data as possible. The other question that you asked in terms of issues related to age and child protection, etc. So there are two aspects there. One is it's not going to be very easy for companies because different jurisdictions around the world have different age thresholds for who is a child. So you can have different age. In India, it's 18. In other jurisdictions, it's lower. And the problem is not so much the age, but also how you get consent is also very different. So in India, in the DPDP Act, you have to get verifiable parent consent. Now, they don't say what verifiable parent consent is. Possibly that will come in the rules, but it's a pretty high threshold. Whereas in other jurisdictions, you can possibly get, you don't necessarily need to verify the identity of the parent. So especially if you're offering a product over multiple jurisdictions, you're going to have a lot of challenges in terms of, especially if you're offering your product to children, you'll have to be very careful about consent issues because it is a little bit of a challenging area.
Right. Thanks, Siddharth. I'm going to go back to what we were discussing before this on the IP part, Murtaza, I think Garima, the question is to you. A lot of game developers, when they start off, intellectual property as a concept is very vague to them, and protecting the same is also very, very ambiguous. So, would you like? What will be your advice towards how should one go about protecting IP, understanding its value for game developers in general?
Right. So I think most of the game developers realize that they're creating something, but don't realize the value of what they're creating, right? For developers, generally, it's about the popularity of the game, or whether the game is doing well, how many users are using, like how many gamers are working on it, and things like that, right? However, when you think about it from a perspective of building something like a game, even the smallest nuance can be protected and should be protected, right? Uh, the first one being the characters that are there, then the world building that happens, even the sounds that certain characters make can actually be unique and protected, right? And of course, the source code, then the type of colors that you are using. So even the smallest thing that a developer uses in the game can actually be protected. And also, when I'm saying that it can be protected, it also has the potential of infringing on someone else's game, right?
Right.
So it's extremely important while you protect your IP, also to make sure that you're not infringing on someone else's. That's the first thing. Now, the second thing is about when do game developers, or when can people actually start thinking about this? And it's as soon as you start creating it, right?
Right.
Because most of the times, and we've seen this with a lot of our clients, that as soon as the game becomes popular, or say it's on number one in the Play Store, you start getting legal notices from bigger corporates, right? And when that happens, that is when they actually go to a lawyer, and it's very simple. Prevention is better than cure, right?
Yeah.
So I would rather advise someone to prevent that legal notice from coming in, instead of going to someone taking legal help once the notice has been hit,
Right.
because by that time the infringement has already happened, right? That's
And
that's
there's a
one
lot of heavy
aspect.
legal costs around that as well,
Yes.
that one must be aware of.
Absolutely, and it actually drags you into a dispute resolution process, which is, as we all understand in India, quite lengthy, right? And also very, very expensive. So when it comes to budding game developers and startups, it becomes extremely heavy on the expense side.
Right.
Yeah. And the second part about is that, even like, say for example, a lot of people forget about the GUI, the graphic user interface that a game is based on. This is one of the most ignored area in gaming IP, and in fact MITI has recognized it as a copyrightable thing, right? So it can be published and you can copyright it. So that's one of the major things that has to be done or protected. So for example, when you see games like say Kurukshetra, or a lot of these mythological games that are coming up,
Right.
they have a lot of these world building areas and a lot of GUI in them that needs that kind of protection. So these are the main aspects of IP. And in fact, if you go to see in the intellectual property universe, there's trademark, there's patent, there's design, and there's copyright primarily. All four of them have a use case when it comes to gaming. So it's not like if something cannot be patented. Like if it's a game, it cannot be patented. That's not the right thing. And it's not just trademark, or it's not just copyright. A lot of use cases come up.
Right.
And intellectual property, as you say, is the value that any game development studio or a startup develops. And
Yeah.
when you think about it from an investment perspective also, investors are investing in intellectual property.
Absolutely.
Right? So if that is not protected, then it's a problem. So when someone is acquiring you or if someone is valuing you, they are going to value you basis those things.
Right.
Yeah.
Right. Yeah, it's very interesting. I mean, one of the most unique patents which has ever been registered is skills patenting. How do you determine skill in a game? So, I mean, it's as unique as that. And the classic landmark case of Free Fire versus PUBG, on where they're trying to dispute on the infringing clauses on both copyright as well as the design sector. So it's very interesting. I think IP, as you rightly mentioned, Garima, the advice will be prevention is better than cure. Of course, summing this entire thing up, I'll come to Amishi. This hearing so many things for a person who's developing a game is very scary, and it makes compliance very heavy. And also, people gets jarred upon the fact that okay, these are all the things that we need to take care of. So, according to you, from a compliance perspective, if a gaming company has to look at what are the top five aspects that one should have in mind when they are operating a gaming company.
So, thank you so much, Ritika. So, first to start about with it, we were discussing the other day that how we can make this more interactive and for the audience to memorize this particular top five compliances. So, we thought that let's come up with a phrase. So, the games itself can be a phrase for those top five compliances that anyone has to comply with. So, as Jay pointed out, it's very important for you to be aware of the gaming regulations in the country. So, until there is a gray space with respect to this, and there is this flux with respect to the regulations governing the gaming regulations, so it's very important to know about the state specific laws. It's very important to know about your GST compliances. So that becomes very important. Now, if you think of it from the first level, it's the game. Then you think about it, there has to be a skill specific element because as gambling is banned in the country. So you need to test about that there is an element of skill involved in the game. Second aspect of it, when you think about it, I would say the content, the IP, that's very important. So you
Right.
need to secure your IP and protect it in every manner. The content, the graphics, the music, trademarks, copyright.
Right.
So that is also very important. The third aspect, when it comes to presenting it in a packaged manner to the user and to the consumer and the players, so it becomes very important that the consumer is intimated and informed about the information that you're collecting. So your data
Correct.
protection plays a very important role there.
Hmm.
So the consents have to be taken. They have to be made aware about the microtransactions that are involved in the game, the in-app purchases. Your website should be, full-fledged. Be talking about the privacy policy, the terms of use. Most important, the last part that the panel has not touched upon, and that is with respect to advertising of your game.
Right.
Now, ASCII has been quite diligent, and although it's a self-regulatory body, it has come up with the rules of when your game or your platform involves real money gaming. It should have necessary disclaimers in place. It cannot be provided to anyone who's below 18 years of age. It should have necessary disclaimers saying that play responsibly. It involves financial risk. No one is better than playing this game. So all these important things are there, and ASCII is the fact is ASCII is taking this very seriously.
Right.
There have been suo moto cases which ASCII has taken up, and it has been saying that these ads are in contravention, and most of the cases have come up with social media itself. So your Instagram ads, your Facebook ads, all these things need to be taken seriously and carefully. So as Garima pointed out very correctly, prevention is better than cure. So it's better that we start looking at these compliances seriously, because in no point of time these things are going to be taken seriously, and this regulatory space where there is a flux, I'm sure something is going to come up which is going to make it even better, and we need to be ready for that.
Right. Thanks, Amishi. I think one more point that Murtaza earlier touched upon was the contracts, right? Like, why is it so important to have written contracts? A lot of time you said when you're raising from friends and families, generally also, and how should you go about having written contracts? So, what? Just for the audience, the importance of having a written contract, and what are the at least the top three kind of clauses that one should keep in mind when they are doing these kind of contracts that are absolutely non-negotiable, or rather favorable, that a game developer should keep in mind when they are negotiating.
I think top three, I think, is a difficult one, but I think it all depends on what kind of contracts you have. But it is important that I know when you're starting up, legal fees is not something that you want to spend on.
Absolutely, yeah.
You also are not really sure which lawyer to go to and all that, but it is something important because I've seen a lot of founders just going online, buying a contract for 100 rupees, 300 rupees, $20.
Just to add to that,
ChatGPT,
please
yes.
don't use ChatGPT for contracts. Please don't.
Yeah, and printing those documents out, and
Yeah.
sometimes even if they're not doing that, they'll go to like some fancy venture capital associations thing. I recently came across an issue where an advisor was advising a company. He had the deal where that he will advise and he'll get 3% of shares in the company when the company becomes bigger. But he downloaded a contract which had nothing to do with that, and he printed it, signed it, and all. And he wanted to enforce it, and it made absolutely no sense. So, but that's on the other side. But even from the side of the companies, your employment contracts, I think, are very key, at least at the stage
Right.
of game development. That, when you're raising money, I think it's more that just call up your company secretary who help you set up your company. They'll be able to at least make sure who to take, who not to take money, set some simple contracts up. But yeah, again, going back to the employment, because other than when you become a much larger company, you will automatically, you're making money, you will think about trademarks, you'll think about registrations. But what comes and haunts you a lot and is say a disgruntled employee who then raises his hand and said, I developed that game, there was no contract.
Correct.
Where I actually had an employment. Many times you don't have employment contracts because you don't want to take the headache of running pay slips, doing TDS and all. So you enter into a consulting contract with someone. And if you don't have a contract which says that, that was contract for hire or for services, then the person can raise his hand and actually get. And the thing about India is that, especially in the courts, while you'll have to wait for 20 years to throw out a tenant, but if there's intellectual property infringement, you can get an order against your company. Someone can get an order against your company to stop publishing that game, and that order can be obtained in a matter of 3 days. And then not every time someone's going to send you a notice, give you a fair warning, and then do it. So what do we care? So that is one area where I would say be
Right.
very careful on. The other things, again, be careful, but they are the things that can be more rectified. You don't really need. You can speak to your company secretaries and other stuff to get.
Right. Would you like to add something, Siddharth?
Yeah, I just wanted to add that, and I think a lot of the panelists have dealt with this point, but it's a lot cheaper and easier to prevent these issues as compared to having to deal with them when they blow up.
Right.
So if you're doing this from day one, just thinking, yes, it takes a little bit of bandwidth, it takes a little bit of effort, and there is a cost, but it's a much lower cost, much less bandwidth if you start from day one as compared to if you have to deal with this at a later stage.
No, I recently did we closed a transaction, and they had engaged game developer in the US to think of one particular game and um, conceptualize it and code it. Now that target company didn't even monetize that game. They shelved that game after a point, but they ended up giving that person around 2% in the company to just settle the
Dispute.
So, and especially, it's a big number. If you're selling a company for 30-40 million, even if 2% goes away to someone else, that's a lot of things
That's
for a
a lot.
game
Yeah,
that didn't even
absolutely.
come to life.
Yeah.
So, yeah.
Yes.
Just actually to add on this, a different aspect, slightly on the TDS part, right? So a lot of game developing studios outsource the development to developers who are outside India.
Correct.
And one of the major issues that they face in with taxation as well as when there's a due diligence happening
Absolutely.
is that they're actually supposed to deduct 20% EDS and then send the money. And when they're sending the money, the game developer who's outside India is not able to take any refund, right? So that 20% is actually a cost to the company, which is really, really high. And people don't realize that till the time they've already set up these things, they've made payments, and after that, the realization comes that, okay, there's a 20% hit that the company has to take on these things. So that's also one of the most important issues that most of our clients face when they're outsourcing this development to people who are abroad.
Yeah, thanks, Garima, for that. Okay, a lot of information for the audiences here. I'm gonna open this up. Thank you so much, first of all, for all this knowledge. I think I'm gonna open this up for questions. Anybody from the audience, if you have any questions. Dil.
Hey, everyone, thank you. It was a very good panel. And Garima, I think we met last year. You did a session here, so pleased to meet you. Right, so I'm Sachin. I'm co-founder of Nightwood Games. We have an office in Bangalore and Coimbatore. We've been running for the last 1.5 years, and we are developing a single-player game, not an RMG, so no multiplayer stuff involved. Plain and simple pure PC game. My question is on the IPs, and so we have GUI, we have UX, we have assets that we're developing or designing for our game, and I'm just wondering, how do we put IPs, like finally do we like trademark or copyright these assets individually, or is it rule? Is there anything that you can say on that?
Maybe.
Okay, I'll start, and maybe you can. It also depends on how much money you want to spend, in the sense that where are you seeing this game going? What do you see your market as? If you think it's got a big market, you're going to make a decent amount of money. It makes sense for you to protect as much as you can. You can protect the characters, you can protect logo elements, you can protect GUI elements, you can protect user interface elements. All of these things can be protected. It's, if you see the market as good, it might make sense for you to start doing some of this activity up front. So there are two ways you can, at least in trademark, there are two ways you can protect. You can protect based on, I'm going to use this in the future, or you can say that I've already started using it, I'm going to protect it based on that. You can, if you have your assets in place, you can start applying for protection even now. And at least with trademark and with other IP as well, the cost is not that high. So if you have a budget, if you have the ability to take that cost, you should protect as much as possible.
Fair.
Yeah, and understood. Last question, I guess. Right, so I basically protect assets that I deem are very key, unique features of my game that I don't want to be replicated. That kind of makes sense. My last question for the day is, you mentioned not to infringe on someone else's intellectual property, right? And there's like a ton of games out there in the market. So either as a developer myself, or probably with hiring someone who does this for a job. Like, how do you even kind of think of what game to look into, right? When so this I think it's a broad topic, but some key.
Garima, do you want to take that?
Yeah. So in fact, I'll just give you an example. So we're just talking about this. So there is, do you know this game called Fallout? Yeah. So Fallout, Westworld came up with a game which was extremely similar to Fallout, right? And what happened is they went into a legal dispute and realized that the way they found out that the infringement was happening was because what Fallout said is that we have a bug in our source code, and the bug was also copied by Westworld, right? So there's no, well, just to add to what Siddharth said, that there's no one glove fits all sort of a thing when it comes to IP protection, right? So a lot of things have to be strategized and thought through, not just from a protection angle, but also from a commercial angle, right? And in terms of infringement, it's also about understanding whether you are blatantly infringing on something, right? Like there are times where people will plaster logos or like brands just in their games somewhere in the world, and that is actually infringement. So, I mean, you can't be so direct that it's going to infringe it. So that's the first thumb rule, that don't just pick up logos or don't just pick up things from different places and stitch them together, right? That's blatant infringement. But in terms of understanding the nuances, of course, if it's a gray area, it's not just, from an infringement side, but also from the person who's creating, right? So it's there are two sides to a coin, but there are sometimes when there are no two sides. If you're just going to take a Cadbury logo and put it in your game, it's infringement. Like that.
So a very
Sorry, I'll just
Go,
add.
Siddharth.
There are certain types of IP where you can do a search. So, trademarks, you can go to the trademark registry and search for the name or the logo or the word, and it'll give you results in terms of there is already protected marks. So there you have some ability to search. In patents as well, but patents is not that applicable to gaming, especially in India. But in patents also you can search for prior art. So some fields you can do a little bit of research to make sure that you're not infringing.
And these are all public information, so everybody can have access to it.
That makes sense. And I guess AI is something that we have not touched here.
The panel is yours after this discussion. Please feel free to.
I'm not asking a question, but I just wanted to give that feedback.
Anybody else? Yeah.
Yeah. Oh, sorry, go on. Yeah, maybe a follow-up question regarding the IP aspect. So one thing would be what would be the right time to start doing an IP before the launch?
Can you be a little louder? We can't hear.
So what would be the right time to start an IP, like before the launch, like once we complete the 60% availability? So most of the time we focus on the global customers. So then we start doing IP. Some of the things may change at the end of the game, even in the game and the logo aspect. So it depends on the publisher.
Yeah, I'll just take that. I think IP is, we use it very loosely. Okay, so there are different aspects to it, right? So if what you're trying to protect is the look and feel of your game, the logo, the name, all of that, probably you want to do that much closer to your launch, right? Because you don't really want the world to know what is going on. You don't want your art and logo to be right there. In some cases, you can do it even afterwards. Because one thing that you need to be careful of, not careful of, but you need to understand is that the protection of IP comes under Indian law in two aspects, right? Especially in copyright and trademark. I'm not talking about patents and designs. One aspect that it comes from is just the fact that you're the first creator. You don't even need to register it. If you can convincingly prove that you are the person who thought of this and you reduced that into writing or you reduced that into a form that can be perceived, felt or seen, right? That is essentially sufficient proof that you own the IP, right? But is that the gold level of protection? No. Your ability, if you get it registered, you are essentially telling the world that not only I'm the first person, I have proven to be the first person because I've gone through the whole process of registering. So my point is, I guess you will take a sensible approach when it comes to trademarks and logos, because you don't want to tell the world what you're doing upfront, right? Because those are things which are searchable. They put up notices to ask people if they have objections. The bigger studios will be fishing out there to stop you from doing something that they believe you are doing and maybe use that as a negotiating thing for something else. So don't do that, right? But that doesn't mean that once your game is launched or whatever, then don't do it. Then you should prioritize it. When it comes to copyright of the source code, I'm not going to touch about it again, but that again is largely protected through employment contracts and stuff like that. You don't necessarily go and put your whole copyright or your source code up and say this is an unprotected. I don't see anyone who's registered their source code ever. Like, technically you don't, because one of the rules of one of the idea of copyright or anything else is that you tell the world what you're doing and then you get protection. It's a bargain. You don't want to do that with your source code. You don't want to tell everyone what your source code is.
Right. Yes, there.
Hey, I had a question. You guys mentioned CAs and company secretaries and stuff, but as like new people who start startups and who don't know anything about these? What's like the right way of choosing a lawyer firm or a CA or a CS? Like what should you be looking for and what should you be avoiding?
The most cost effective. They will kill me for that answer, but yeah.
What I mean, in the end, you want. I think in the end, you want your anyone who's professionally advising you to sort of give you or guide you in the correct manner, and while they're doing that, also reassure you or sort of give you that comfort that I'm being guided well. I think that's the most important. It's as simple as going to a doctor, right? I mean, when I go to a doctor and that doctor is going to tell me that आपको ये surgery चाहिए and you have to get these things done, I'm going to get scared, right? And probably the next time when I want to go to the doctor, I'm going to think 4 times before going to that same doctor. Whereas if there's someone who's going to sort of reassure me, guide me well, but also not take me lightly, is the probably the right fit.
I'll just add one thing. Cost is of course a factor, cost and budget. But second thing is, you might want to look at someone who knows a little bit, is
Right.
familiar with the industry,
Right.
who is, maybe even if not a specialist, who is completely not blank about the whole thing, who knows about the compliances and maybe who has worked in the past and at least is aware. I think that is something that is also important, to go for a sort of a specialist, as specialist as your budget may permit.
Yeah, right. I think one thing to also keep in mind is, usually as a game developer, compliance and of course legal and all of these aspects is always looked at the cost center, right? Because that's not your primary focus. But as Garima mentioned, prevention is better than cure. Even though it is a cost center, spending that money today effectively on a specialist is going to save you a lot of bucks later. So that's very important. And look around. There are so many other examples. Who are they advising? Who are they taking help from? You will have your answer there.
Thank you so much.
Any other questions? We will be able to take 2 more questions because I think the time is up.
Suppose a person is developing, let's say, a general software application in which they've embedded a sort of gamification for, let's say, some coupons or anything. It could be either cash or non-cash. How is that treated? Is it treated as a game or is it treated as an application?
I would say, one aspect you have to be careful about over here is also the consumer protection
Correct.
aspect, because there could be certain categories of games, etc., which could be treated as an unfair trade practice. So, you have to be careful about that, and of course, anyone else.
So I mean, this is going back a long time, but if you would seen all of these contests that people run on, TV channels, radio channels, etc., they always ask you a question, and that the reason they do that is that there should be an element of skill. So even if you're gamifying something, it's always good to make sure that there is some level of skill involved. It's not completely random, because then you get into this whole issue of gaming versus a game of skill. So that's one thing that you should always keep in mind.
Right. Thanks.
I think we just have time for one last question if there's anyone.
Hi. So when it comes to people those who are writing the scripts and stories for games, when tackling storylines that are, let's say, controversial in certain surrounding controversial topics, can there be any foreseeable consequences when it comes to the law?
Can you give an example for the panel to understand better?
For example, games that are surrounding terrorism, for example, or Nazism in historical facts.
Okay.
So there are general laws, under the IPC or now BNS, or surrounding women or children and other things. So you have to be very careful, because and hurting sentiments is also an offense. There are various kind of offenses under the criminal law that you may fall under. And India is a country where a billion sentiments, billion people are always hurt. So you have to be very careful, and that aspect. So not religious issues or issues around women and other things, you always got to be careful, and I would say err on the side of caution rather than putting out controversial content, or get it vetted before doing that.
Right.
Yeah, I think from my perspective, I distinguish between my personal views and the professional views. Personally, I'm fully on board with you being able to say whatever you want to say in the way that you want to say it, as long as you're being sensitive. But from a lawyer's perspective, exactly what Jay is saying, being very careful. The environment in our country is very enforcement focused at the moment, so you don't want to be in a scenario where all your work is going to waste because somebody has an issue with it.
No, I was asking from the perspective of how other games do it, such as Call of Duty, or like when other games tackles these topics.
So
Not from my own perspective.
So not just with games. I think it's a issue with anyone who is expressing
The entertainment sector,
content,
press, and
the entertainment sector. So I know for a matter of fact, like for example, stand-up comedians, they're the classic case of offending people and talking about issues which could, this thing. So a lot of them now, and I know it as a matter of fact, they have lawyers on retainers who run through their content or script, right? So I think once you know that you are in that territory, then it is potentially good to get a litigation lawyer. Don't come to one of us. We'll charge you, but we'll give you terrible advice. But go to a litigation lawyer who does that kind of work, to just whoever it is, right? And that's what people do, to just go through that kind of script or the work, or because even if there are ways to express, because you see movies on terrorism, you see movies on Nazism. It's not that you don't see them, but they are careful, right? So even if you see, Oppenheimer, which came out recently, the movie, they touched on a lot of political issues which were relevant at that time, and I'm sure they were very careful about getting the right legal advice to make sure what they can disclose, they can't disclose, what they can talk about, what they can't talk about. So, yeah. People do that. They have laws and retainers.
okay.
May I ask one last small
Sure.
question? In certain scenarios, when it comes to the law, there is, from my minimal knowledge of it, there are certain scenarios where there is a first to use and a first to file basis. So does that also apply for storylines or IP protection or
Copyright. He's asking about
things.
copyright.
So, see, there's an idea and expression dichotomy. So, if you have an idea but it is not expressed in a particular form, then that is not protected. If you've expressed it in a particular form before anyone else and it's recorded somewhere with a timestamp, it becomes
Say, for
easier.
example, a game is released with a storyline which has not been trademarked, but it is a first to use basis.
So the game has been released, right?
For
so
example.
the expression is already done of the idea. So you've already, basically the IP is of the first to use.
Right. So in that case, the person does not have to trademark the IP before releasing the game.
So trademark is only for your logos and your
As in
design, but
Copyright.
you don't have to necessarily register the intellectual property.
All right.
Okay, I'll just add to that. So, you've released your game, you've not protected the logo. Okay, somebody else goes and tries to register that same logo. So then you have to go and try and challenge their registration. So it's not enough to just put out your game. The moment you have the budget, you should register the trademark as well.
Yeah, but again, depends what you're doing, right?
Yeah.
So assuming you think of a monkey with 8 legs, right, and with a red MAGA hat running around your game. So that the fact that you've reduced your artist has reduced that thought into a pictorial form. The copyright has come into
Existence.
place on that day.
Yeah.
Because you own the copyright for that, right? Now, if say Siddharth comes and says, "Listen, I thought of this before you," Siddharth will have to prove that he had reduced a similar monkey with 8 legs and MAGA hat, somewhere else. If he can't, then you don't even need to register your thing, right? But if you believe that if your game goes up and then you are actually want to sell merch with the thing, then you will probably go to the trademark registry and say, "Listen, I want to register this whatever character I've created as a brand."
what happens if someone proves that, like, someone has generated a monkey with a 8-legged monkey with a red hat with AI before you?
Yeah, so it's tough. So then we get into the whole realm of did he use AI as a tool? If he used AI as a tool, then it is were the prompts good enough for him? Well, if the prompts were good enough for him to create it, then he is a creator, right? So on the AI is a little dodgy because the answers are not there. So I mean, but if someone else had created this somewhere else, then the question is, did he publish it? Did he not publish it? Is it within your juice? So you get into a lot of nuance, but the thumb rule is that the idea is not sufficient for protection. It needs to be reduced to a form, and once it comes in public, you as I said, you have some defense of protection. Is it gold standard?
Amishi, would you like to add?
Also, you need to understand the difference between the trademark and the copyright. So the two play a very different role. So for say your logo or let's say your name itself is a trademark because you will be trading through that name, and particularly you will be advertising your game using that logo and the name, right? So for that, as Siddhartha also pointed out, that there's a prior usage and there is a proposed usage. So for the prior usage, you will then have to collect the evidence and prove it and give it to the registry that yes, I had so many number of invoices, so many number of receipts. So that's how you have to prove it also. So you need to understand the difference between the two, and that's how you should take it also while you are protecting your trademark and the copyright.
Thanks. Okay, thank you so much. I think it was wonderful having all of you over this panel, and we had discussed a lot of topics, but of course we have just touched we are on the surface level of it. Very exciting times coming up, a lot of things happening in the gaming sector, specifically on the regulatory side. A lot of you will be very, very busy with it. So, and of course, anybody has questions, please feel free to reach out to them directly, and I'm sure they'll be happy to help you guys. But thank you so much for your time.